Welcome to Political Empire, your daily source for inland politics news and analysis. I'm Jeff Horseman with the pressenterprisemp.com, here to talk about medical marijuana. An attorney known for taking up environmental causes is suing the city of Murrieta over its ban on medical marijuana dispensaries. And joining us by phone to talk about the case is reporter Dave Downey. So, Dave, who is the attorney in this case, and why is he taking the city to court?
The attorney is Ray Johnson, who is based in Temecula, and he's well known throughout the inland area for his mostly successful challenges against big box stores and other development projects, including the Paris Valley rail line, on environmental grounds. Johnson is taking Murrieta to court because he says the city was obligated to study the environmental impacts of their decision on traffic and air quality, given that medical users will now have to drive outside the city to legally obtain marijuana from a dispensary.
All right, and what's been Murrieta's response to his suit?
Well, not surprisingly, the city disagrees. Murrieta officials contend that they do not, in fact, have to conduct a study because a ban was already on the books, and its new ordinance merely moves the ban to another section of city law. Murrieta patterned its latest ban after one in Riverside that was upheld in May by the California Supreme Court.
All right, well, thank you very much, Dave. We appreciate your time.
Very welcome. Thank you.
We are now joined by reporter Rich Diatley, who's written extensively about this topic. So, Rich, I thought the state Supreme Court had already decided cities could ban dispensaries.
Right. The court did say in May that there's nothing in the current laws that authorize use of medical marijuana that grant a right of convenient access for users, and nothing that overrides local government zoning powers, their ability to ban them. They didn't address anywhere in their decision environmental issues. They weren't raised in that particular lawsuit. And the only city in Riverside County alone is Palm Springs, where medical marijuana may be legally, or there's no ban on dispensaries, but they have very limited because they only do it by permit from the city. The other thing is, in the law, as it exists, is that users are permitted, authorized users are permitted to do personal cultivation or join a non-profit collective for cultivation and distribution. That would seem to eliminate perhaps the issue of travel and environmental impact. Those are some of the challenges I think that you could see that this lawsuit would face.
All right, and anything else happening on the medical marijuana front since the Supreme Court ruled?
Most of the cities that we have talked to have now, where the ban is in effect, have said that they have eliminated all of the medical marijuana storefronts from their areas, and they continue, we understand, to look for enforcement in case one pops up, but if they do, the ordinance people are on them pretty quickly.
All right, well, this is an interesting challenge and a very controversial topic, and we'll be sure to follow it. And thank you, Rich, for your expertise. And thank you for watching Political Empire. We'll see you next time.